The Supreme Court has overruled its own decision after 26 long years. And in a rare bonhomie, political leaders across party lines have welcomed the order. But in this election season, what does this mean? Our times have changed drastically from 1998, from resort politics to the series of cross-voting. Now seen as usual, can MPs and MLAs, representatives elected by you and me, finally be prosecuted for taking bribe and voting or making speeches in Parliament and Assemblies? How is this different from the constitutional immunity given to them? First, let's start with what the court has said. The 7-member Constitution bench led by Justice Chandrachud has held that a member of the Parliament or the state legislature cannot claim immunity from prosecution on charge of bribery in a criminal court by virtue of Article 105 and 194. So what are these articles? These two constitutional articles exempt MPs and MLAs from any legal action for any statement made or act done in the course of their duties. However, it is a protection given to perform their duties to MPs as well as to MLAs, like against a defamation, as he or she raises an issue of public concern or concern to his or her constituency. I'm giving defamation as an example, that it can curtail the duties that they are performing. And very importantly, that this does not extend to prosecution for demanding or taking a bribe. And that immunity to legislators under the Constitution is valid only if a twofold test is satisfied. The twofold test involves examining whether such action is connected to the collective functioning of the Legislative House, or the action has a functional relationship to the discharge of the essential duties of a legislature. But the court has said this does not mean for bribes, taking or giving. Now, what is the 1998 PV Narasimha Rao case? The opposition introduced a no-confidence motion in mid of 1993 against the PV Narasimha Rao government that was elected soon after the assassination of the earlier Prime Minister Rajiv Gandhi. The Congress at that time had 251 votes, including those from other parties offering external support. They were short of 13 votes. However, when voting took place, the government survived by a 14-vote margin. A year later, there were allegations that 6 MPs from the Jharkhand Mukti Morcha, JMM, including party stalwart and former Chief Minister Shibu Soren, had taken bribes to vote for the government. However, at the time, the court held that the lawmakers' immunity from prosecution extended to votes and speeches in the House. This was a reference and inference of Article 105 and Article 94 of the Constitution. And this then is very famously known as the 1998 PV Narasimha Rao case, which literally allowed him to survive, the government to survive. Interestingly, and not coincidence, today's landmark order comes as the daughter-in-law of Shibu Soren, Sita Soren, an MLA, who was accused of taking a bribe to cast a vote in a Rajya Sabha election, moved the Supreme Court claiming immunity, citing the 1998 case. But what does this really mean for voters like you and me? Would this, in very simple words, mean will MPs and MLAs now toe the line that they are supposed to toe? Will they now refuse to take bribes? First, let's listen in to what the Supreme Court said about the very, very important inference of the two articles that shields the legislators, MPs as well as MLAs, according to the Constitution.
1052 and 194.2 in the manner proposed in the majority judgment results in a paradoxical outcome. Such an interpretation results in a situation where a legislator is rewarded with immunity when they accept a bribe and follow through by voting in the agreed direction. On the other hand, a legislator who agrees to accept a bribe but may eventually decide to vote independently will be prosecuted. Such an interpretation belies not only the text of Articles 105 and 194, but also the purpose of conferring parliamentary privileges on members of the legislature.
And I'm being joined right now by R.S. Patania, the spokesperson for BJP, Desh Ratan Nigam, lawyer, as well as Sulaiman Mohd Khan, spokesperson for Congress. I'm also going to be joined shortly by Tehseen Poonawala, who's a political analyst. Thank you, all of you, for joining me. First, let me just go over to you, Desh Ratan Nigam. How do you look at what's happened in the court today? We've tried to explain the difference between a constitutional shield which is given to the legislators, as well as what was the inference in 1998. Across party lines, politicians have called this long, long overdue.
It's an historical judgment, Sneha, and a landmark judgment which should clean up Indian politics. And therefore, it is for everybody to welcome it. Some probably may not be very happy and alarm bells may be ringing for some of them. But the truth is that it was long overdue. The earlier judgment clearly appears to be shielding the then Prime Minister. It had no sense into it, and it took 26 years for the Supreme Court to give a common sense judgment that somebody takes a bribe and then makes a speech in the Parliament or votes as per the control of the third party. That is a crime and needs to be criminally prosecuted under Prevention of Corruption Act. And Section 7 of the Prevention of Corruption Act clearly defines what a bribe is. Even an attempt is made, then it's a punishment. It's a crime under the Prevention of Corruption Act. Not only taking bribe, but making an attempt, and which is defined in the IPC. Therefore, this is a landmark judgment, and the earlier judgment and the position of law clearly was in favor of betrayal of trust of the people who elect a particular person with a particular ideology and a particular thought process. And that is always denied by, when we see crossovers, transfers taking place, cross-voting taking place, and things like that. That is if you have taken a bribe. Otherwise, independently, you are free to make speeches. Whatever you may say inside the Parliament, you have privileges. But once you take a bribe and then vote, then that's a crime. And this was long overdue. And coming just before the elections, I'm sure this will weigh in the minds of...
across political lines to this verdict has been welcomed today. But what did you mean the alarm bells might be going and some may not be happy? What are you trying to infer?
Yes, when the judgment comes, it comes in the wake of the present facts and circumstances also, apart from constitutional validity, because when the arguments are done, you have that Jharkhand bribery case also. Certain things were there and they went unpunished. In fact, the governments were saved at that point of time. So there are people who try to promote this kind of politics, and that is to be prevented. Bribes, taking gifts, monies, making speeches on behalf of businessmen in the Parliament. All those things have to be, nipped in the bud itself. And this is a judgment which will nip it in the bud. And anybody who flouts it will be criminally prosecuted under the Prevention of Corruption Act. And if he money launders it, or if assets are disproportionate to his income, then all those acts and criminal offenses will come of money laundering and disproportionate assets.
All right.
And I think the politicians will be very careful from now
react to this. All right. R.S. Patania, Prime Minister Modi, of course, welcomed it. In fact, not just Prime Minister Modi, as I said, across party lines. But, one of the allegations that's really come up against the BJP is the poaching that takes place, is the cross-voting that is encouraged. These are the allegations. Of course, this is very, very different in the context of bribe for voting, bribe for speeches. But where does one draw the line politically, especially for voters who have voted MPs and MLAs to power for a particular party, for a particular line?
You have very much hit the nail on the head. This is really a path-breaking judgment. This will mark a new milestone in the parliamentary history of India, and more so another milestone on and rather a defining moment in the political history of India also. This poaching, this is a very mundane and a nasty term for the elected, the honorable member parliaments and the MLAs also. This should end, and it is in the interest of India as a nation, as a state, and as a healthy functioning parliamentary democracy. We should rise above it. You see, this is the settled proposition of law. No right, even the right of freedom of speech and expression, it's never an unqualified and unviolable right. 10 law, the right to enjoy privileges under Article 105 and 196. This was an unqualified right. And a big fraud and a big wrong was being put under the carpet, under the garb of this PV Narasimha Rao versus state judgment. But now I think the closet has been opened. The Honorable Supreme Court has drawn a very intelligent decision. They were differed from the law enunciated by in the British Constitution also. I think the double test which has been defined, it will be act as a harbinger and as a lighthouse for the coming situations and the coming points to come. We should welcome it, we should deliberate it. And this is the beautiful emancipation, a exposition of law by the Honorable Supreme Court. Law changes as per the situations, as per the circumstances, as per the exigencies of time and place. And in one line, if I have to attribute, this is a very beautiful exposition by the Honorable Supreme Court, particularly in the present exigencies of time and place. And with regard to your first point that you said, with regard to poaching and all that, we strictly deny, we dispute, and we deprecate also any attempts to poach, to buy, and to hire and purchase such something like these MPs or MLAs. We are absolutely against it. Bharatiya Janata Party believes in probity and in cleanliness in public life and in political sphere also. We believe in a very transparent and accountable system of workings. So at the end, we welcome it.
Okay, let me get in others as well.
We welcome, please. And we call upon
Sulaiman Mohd Khan, you've heard what R.S. Patania has said. They're saying they're completely against poaching. They're completely against cross-voting, if I may. They believe in absolute clean politics. How would you interpret this, along with what the Supreme Court has said in the current political scenario?
Sneha, it's quite funny to hear all that from a BJP spokesperson, because in recent past, what we have seen, that in elections to Rajya Sabha very recently, our MLAs have been poached, etc. Today, the judgment, I'll come back to the point. The judgment of the Supreme Court, we welcome it on behalf of the Congress party. It's a very good judgment. I think the privileges which the Constitution has given to the parliamentarians and the members of the state legislature were given for discharge of their responsibilities or the duties which has been bestowed on them through the electorate. But those privileges cannot be used to cover up your illegalities, briberies, to vote after taking bribe, or to give a speech after taking bribe. So this is a correct position. I think everyone will welcome it, and this will actually, Sneha, what we were saying earlier, this will actually stop this poaching issue, because now some MLA or an MP is cross-voting after taking bribe against a particular position. To my understanding, that will be under the radar of the investigating agencies, and these privileges which have been
no, but Sulaiman, isn't this the point? It is, unless you prove a bribe has been taken. In how many cases can you actually prove it? It could very well be independently that they have voted over. That's where the real, in 1990, what happened in 1998, there were these allegations of bribe being taken. Court has said taking bribe or allegations of that is an offence. But how much of that can it really be established with respect for action to be initiated against the lawmakers, particularly in the current, and we're going to see more of it, I believe, ahead of the 2024 elections?
No, I think, to my understanding, the points you are raising these are all matters of investigation and subsequently matters of trial when the matter goes to the court after the framing of the charge. So to my understanding, we cannot, laws are made, they are being interpreted. A 5 judges bench judgment came, which has actually been overruled by this 7 judges bench judgment. Now, I think this is the correct position of law. And we hope and always believe, and we hope for the future, that this will be followed. The investigation will be good, the trial will be fair. So these are all hopes. We should always be very positive. To my understanding, this will be a deterrence for people who take bribes and vote against by taking bribes and give speeches which are completely corrupt by taking bribes. So I think it's a good judgment, and anyone doing this will be, subject to investigation and prosecution.
Okay, all right. Tehseen Poonawalla, now we also heard Desh Ratan Nigam make passive references to that. But as soon as this did come up before the court, one of the things that did emerge soon in the political circles were about cases that may come under its spectrum. It's important to differentiate here. Supreme Court's verdicts don't have retrospective effect. But something that has been raised by political parties today is the Mahua Moitra's case. And they are making references to it. They're also talking about how this may have. Now, that the House is divided on that. But quite frankly, with what has happened in the court, again, beyond the political bickerings, how much of this do you really see clean the House ahead of the 2024 elections? Because bribe taken or not is very much behind the walls. With the way political spectrum is being swept right now, the way cross-voting, resort politics, poaching is all becoming a pattern ahead of elections. In fact, journalists also prepare themselves to go and report all these things because it's becoming so common now. How does this really affect voters who are going to be voting and electing their elected representatives?
So good evening. Thank you so much for having me on the show. And at the onset, parliamentary immunity is a privilege, but it's a privilege that has certain limits. Like everything in our constitution, there are certain limits in everything in our constitution. So for example, I cannot commit a murder in parliament, or I cannot pickpocket in parliament, though there are quite a few pickpockets who've been pickpocketing our votes by cross-voting in parliament, but you cannot do that. That, just as you cannot do that, there's no parliamentary privilege. Similarly, there is no parliamentary privilege for taking bribes. Now, obviously, this was commonsensical. You cannot take a bribe and vote, or go the other way, or take money for questions. Now, the technical argument to this, or those who are convicted, was this money was taken outside Parliament, not inside. But the act was performed inside Parliament. So now the Supreme Court is very clear on that. However, what is judgment? And I'm still going through this judgment. And I think where the key area to keep your eyes on, and for constitutionalists will have to be, is two. One is cross-voting, like you rightly said. Now, what constitutes a bribe in cross-voting? Let's assume I am the chief minister of a state and my government is going to be destabilized by the BJP, or I am from the BJP and I want to destabilize the government, or I'm from the Congress, I want to destabilize the government. Is bribe merely cash or jewelry or watches or lipstick or anything of those? Lipstick because I'm alluding to a famous case that happened recently. Or is bribe more than that? For example, Yediyurappa ji, when the Congress government fell, the Congress JDS government fell in Karnataka, this is the last government, and Yediyurappa ji became chief minister, he comes on record and he says, in fact, that bites with the Times group, look, everybody who's come on our side will be made a minister. Everybody. And they've all made ministers. Is that a bribe or is that not a bribe? So it's something that you have to understand. What constitutes a bribe, what doesn't? Is ministerial posts for toppling an elected government on whose symbol you have been selected also a bribe or no? Second, this also makes the role of the speaker extremely important. Third, how does this function when it comes to giving a speech in parliament and a vote? Now, does this completely, while there are, well, obviously money taken for giving a vote, what if I, as an independent legislator, decide to vote with my conscience for whatever reason against a ruling party, maybe against the Congress or the BJP or against the party I've been elected on? Now, does that somehow curtail my democratic right to vote freely? I think these are questions that will require further study. Also, there is the 10th schedule of the Constitution, the whips which are routinely being flouted. So all of this in time will evolve. There will be mechanisms, but the role of the Speaker and the House will become even more important. Now, the Speaker can't be biased here, because imagine a situation where the Speaker says, look, I think our government is going to fall. Let me give you a hypothetical situation. A group of legislators are very unhappy with the Chief Minister and decide they want to drop the government. But now, because the Speaker is close to the Chief Minister, says, hey, these people have taken bribes. We have certain allegations. There's a police case that's formed. Therefore, this is bribe and this vote will not be accepted. Now, while the investigation will take place, the government will be saved. So I think these are things we have to deliberate very strongly as a country. I, in principle, welcome this judgment. I'm also very scared about one very minor aspect, with votes and toppling governments. I'm okay with that. But if the courts are going to look into speeches made in Parliament, and there's going to be court interference in that, it makes me a little uncomfortable. I don't want parliamentary speeches to be in court domain. Both legislator and courts should stay away from each other. Just like as a parliamentarian, I cannot interfere in a court proceeding, or I cannot tell a judge how soon a case must take place, or what his judgment should be, or her judgment should be, or how she should proceed in a court. Similarly, I find it not comfortable courts telling Parliament so much. It exceeds to the point where sometimes courts tell Speaker how a vote should be conducted, how it should be recorded, those records should be submitted to court. While I understand the larger principle, we have to draw a fine line on that for our democracy to survive, because both of these are separate arms of the government. They cannot. The Constitution is supreme. In India, neither Parliament is supreme nor court is supreme. So I think we have to get that balance right.
Tehseen, you made some very valid points. Desh Ratan Nigam, if I can just come in, get you in at this point, and just, would you have, I mean, how do you look at bribery when we are talking about bribery? Is that something defined? Is it something that has to be tangible? Because, I mean, quite openly, bribery can have a very wide ambit also. It could be also a lure for a particular seat that could have been offered. How do you then decide and conclude on what is bribery? But also another point that Tehseen was raising, he's talking about judiciary being very different and separate from the legislature. Fair enough. But here we are talking about vote for a bribe for vote or speech. So in that case, are there concerns as he was raising?
Yes, Sneha, two very important points only an accomplished lawyer could have found in this judgment, which Tehseen Poonawalla did. And let me tell you, if you have to think of in terms of bribe, how Prevention of Corruption Act defines bribe. It is undue advantage. They use the word undue advantage that you have taken. So it could be money or otherwise, both. It could be, as in the Mahua Moitra's case, there were other, influences that were used. So undue gratification and undue advantage, although the section headlines uses the word bribe, but inside they use the word undue advantage. So both aspects would come into the picture. The second issue that he has raised is the encroachment by the judiciary onto the parliamentary functions, rights, and privileges that they have. That's a very important issue, because we have seen sometimes the courts interfere in the legislative functions and try to make law. That is where I have my reservations from, where the Supreme Court, there are clear defined boundaries between legislative functions and judicial functions. The judiciary needs to only interpret it, see its constitutional validity and illegality, nothing else, nothing more. There is a possibility, because this judgment also makes it a point that parliamentary privileges are under judicial review. That point has been emphasized here. So one has to be very careful, because there are certain domains which are within the parliament. They must vociferously, preserve that domain. Do not allow judiciary to interfere in their domain, because that's important. However, a crime which is committed needs to be punished. That immunity cannot be given. That Supreme Court has done so in this particular case. But other privileges and immunities which the parliamentarians have for proper collective functioning of the parliament, or which is part of their integral duties and responsibilities, that has to be preserved. Otherwise, there will always be sword hanging on the heads of the parliamentarians, what the Supreme Court may think about it. They will not be able to freely air their views or the aspirations of the people. And that is where I have my concern, as rightly raised by Tehseen Poonawalla.
Aris Patania, to what both Tehseen Poonawalla as well as Desh Ratan Nigam have said, you as well as Mr. Sulaiman, how do you look at this being, the spokespersons of two political parties officially? Aris Patania, one, you have the two articles, 105 and 194, which give the protection to the legislators. However, if there is an excess of or breach of freedom of expression, as it were, it's the speaker who's in the final authority. But would the developments now, which is in the parliament, be subject to judicial scrutiny? Would that make you all uncomfortable?
Absolutely, Sneha, absolutely, you're right. And I think the issue which my learned friends have flagged, it really has chorus and meaning in it. On one point, the independence of
Okay.
judiciary, this is the basic structure of the constitution. But on the other side also, a parliament functions in a free and a fair manner to discuss, to debate and deliberate. This is the basic functioning, as it is the basic cornerstone of the parliamentary democracy. And for opposition, as it is said, to oppose, to expose, and to depose. So within all these parameters of discuss, deliberate, and then debate. So within that, at every point, if judiciary comes to rap on the knuckle, that's not a healthy sign. But let us take it on a positive sense that morality in politics is the cornerstone now. It is the public cry now. And the
Is
day-to-day
it?
incidents which
Is
are
it the cornerstone?
happening, the way
That's a very
the parliament.
high. That's a very high armchair that you are sitting on, if that's what you're saying.
That's absolutely, madam. But I'm especially saying that the fine-tuned system of checks
Okay.
and balances, and every institution stays within its limits. Though every institution corrects the other institution, but I think the propensity of the institution should be that it corrects itself out. So parliamentarians should flag the issue.
All right.
So
Okay.
there's
Let me
no
just
need
get in.
to
Let me just
citizen
get
or
in. Sulaiman
to
Mohd
parliament.
Khan. Right. Sulaiman Mohd Khan, how do you look at today's judgment and the cases that it might impact? We of course have cases that got brief mention, like Mawa Moitra's case, but also Ms. Soren's case. But largely, how do you look at the cases that may come up before the court or may come up before the political spectrum in the light of today's court case?
I agree with my fellow panelists, first of all, that the role of the courts and the legislature and the executive have to be demarcated. And it's completely agreeable. And it is also a matter of concern that how the bribe, it's only physical money, which is a bribe, or some gift that is a bribe, or something else in cases of poaching, etc. So these are matters which need to be deliberated subsequently as things will come to the forefront. Things will, evolve and the interpretation will be done. As far as this judgment is concerned, I think, to my understanding, there was, to my understanding, there was misuse of these privileges by parliamentarians and legislatures in cases of these corrupt practices. These privileges were for positive things and for protection in cases in the responsibility which a parliamentarian or a state legislature has to actually discharge. But if you are doing something illegal, then you need to be prosecuted, to my understanding. But yeah, certain checks and balance with regard to the interference of the courts has to be, maintained. This is actually the constitutional principle. These are three wings of the constitution: the parliamentarians, the legislatures, the executives, and the judiciary.
Right.
Everyone has its own domain. That has to be respected.
Okay. Tehseen Poonawalla, just the last question to you. In fact, it's very interesting how the Supreme Court has itself said that this is common sense and it was long overdue and has gone ahead to make the orders that it did. But the fact is, why can't representatives who have the offense of bribe or eventually are proved for it, which was very rare because, this was an immunity that they got, why should they continue to be an elected representative in the very first place?
Yeah, I agree with you. Why should they? But look, I think we're conflating issues. Let's say XYZ gotten bribe. That bribe was not given inside the legislature or the parliament. So the immunity itself did not come into force because any money that exchanged hands or gifts that exchanged hands was anyways outside. So that was a criminal offense in any case. So that immunity in the first place should not have been there and the prosecution should have been there. To that extent, I agree with the courts correcting the wrong. But here is another question, and let me play the devil's advocate with absolute respect to the majesty of the court before whom we all bow, and I speak for everybody. Why isn't how judges are chosen by the consortium? Why isn't that in public domain and a video streamed? Why is there that certain families continue to be judges? So I think these are questions that also the judiciary, which does like to preach transparency to parliament and parliamentarians who are directly elected by the people, and I respect that. Why don't they also follow it? For example, who gets assigned which case as the master of the roster in whether High Court or Supreme Court? Why can't that be an automated process where a computer picks it up and the Chief Justice only in case of some emergency sits on it? So even the judiciary must self-introspect and get in reforms within the judiciary for greater transparency. Now imagine hypothetically, let's imagine, because the Prime Minister is a very powerful Prime Minister, and I oppose the Prime Minister. Let's imagine the Prime Minister says, look, this is a system we need to change in the judiciary. The judiciary will unite and say, no, you cannot interfere in our domain. Then, should the judiciary be interfering so much in a parliamentary domain is something all of us must reflect. I'm not saying that the bribes are right. I'm saying in any case those bribes were given outside the parliament or outside the assembly. That money wasn't got inside the house and given. So in any case that was a criminal offense. That should have been prosecuted. But now to say, look, we will even look at speeches. It worries me. Let's assume I'm a member of parliament from a political party and I decide to give a speech in the interest of my constituents who send me to parliament, which perhaps may be against my party, which is maybe in government. Now if I'm prosecuted by the government of the day for taking a bribe, say a false case is put, and now court is deciding something I said in parliament, how worrying is it for me as a legislator? I think we should think about it very, very seriously, because remember in Pakistan, 2 serving prime ministers were called to court. I'm not saying they were dismissed by court. Dismissed courts did. They were summoned inside courts, physically summoned inside courts. We have to be very, very, very careful. Once this slippery slope should never be crossed. I'm saying this with greatest of respect to the courts. I don't think this will happen in India, but we should be very careful.
Desh Ratan Nigam, last remark to you to just look into what Tehseen is saying. He's raised some very strong objections, concerns that any valid citizen would really do. It's not about which political position one takes. But Desh Ratan Nigam, even to what Tehseen is saying, you do have the impunity of what otherwise the 2 articles, the constitutional articles would do promise. So wouldn't that then act as a bulwark?
See, Tehseen has raised some very important points. I've always maintained that the collegium system of appointment of judges have to go lock, stock and barrel. And there has to be a system which is accountable to the people of this country. Appointments of the Supreme Court, bad, good, worse, are not accountable to the people. So earlier, the original position of...
Fair enough.
The original position was the appointment by the parliament. If they do anything wrong, they are answerable to the people and accountable to the people. And therefore, that reforms within the judiciary is the call of the day. They have to make a call and the parliament has to assert itself. NJAC was a good beginning, but for some reason it was struck down. And there was a lot of ifs and buts in that judgment as well. However, the flags that we all are concerned about is that the parliament is supreme so far as legislative functions are concerned. And it must remain supreme. It can even overturn the judgments of the Supreme Court. This parliament has been quite respectful towards the judiciary. They have not yet done so. But the fact remains that they are supreme, they are accountable to the people, they reflect the will of the people. And the Constitution also is by the people. And therefore, the will of the people must have supremacy, yes, guided by the constitutional principles. These are the red flags that needs to be deliberated upon.
All right, thank you very much, R.S. Patania, Desh Ratan Nigam, Sulaiman Mohd Khan and Tehseen Poonawalla for joining us. This has been a discussion on perspective, some very important issues that have been drawn in, not only in terms of what the order stands for, but the challenges that may really emerge and a delicate line which is drawn between what is the right and what is the duty and where does judiciary and the legislature meet or not meet. Thank you very much for joining us.